Hi, Worship. We are starting in 15 minutes and we are already online at 9. Is Petro written? You might want to log in earlier to get contact. Yeah. Hi members, please turn on your videos. I just want to see how they're working. Good morning. Hello Dawn, hi Lillian. Yes, excellent.
Good morning. I hope that
good morning.
the day has started well for you.
Yeah, hopefully.
All right.
Yeah. Hi Lillian, how are you? You're muted, Lillian. And Davis, you might want to
Sorry
put,
about that. Good morning,
okay.
Madam President. Good morning, Dawn.
Good morning, Lillian. Davis, you might want to put that Donald there is the CEO of the Pan-African Lawyers Union, so that it's right there. I know he's very famous and everybody knows him, but you know. Okay, so this is fine. We can take off our videos. Then when I'm going to introduce all of you, it would be nice just to switch on your video. Thank you.
Okay.
Good morning, ladies and gentlemen. You are very welcome today to this public interest litigation webinar brought to you by the Fidelis Leadership Institute in partnership with the Pan-African Lawyers Union. I would like to recognize our esteemed guests and our chief guest of today. One of our esteemed guests is his very self, the Honorable Attorney General of the Republic of Uganda, Honorable Chiriwa Chiwanuka. We support, sorry, we we salute you. I'd also like to recognize His Lordship, the Deputy Chief Justice of the Republic of Uganda, who's a guest of honor. He's already in the room somewhere, and we welcome you, Your Lordship. We're very honored to have you. We have one of our keynote speakers, Mr. Donald Dare, the CEO of the Pan-African Lawyers Union. You are very welcome. We have Ms. Lillian Agwang, the CEPIL, which is Center for Public Interest Litigation. Lillian, it's really good to see you. I think the ULS family is proud of you. You've served us very well. It's good to see that you're in CEPIL. I would also like to recognize Ms. Linda Kasonde. She is the immediate past Vice President of the Commonwealth Lawyers Association, and she'll also be online shortly. We are also going to hear from Ms. Susan Baluka representing FIDA. And one of last but definitely not least, we also expected to listen to Mr. Ben Twinomujuni. Yes, he is Professor Ben. He is a well-known figure to all of us. I think he's taught a lot of us at Don from Makerere University. He is seasoned and he has earned his stripes, and his passion for public interest litigation, especially in the health and environment sector, is well known. We used to know him as Shokoro, our lecturer. So you're very, very, very welcome. I see people online and I would like to recognize you all. Members of the Law Society from the Pan-African Lawyers Union, the Commonwealth Lawyers Association, Uganda Law Society, East African Law Society, would like to recognize you all in your different capacities. Public interest litigation is the lawyer's tool for addressing wrongs, for righting wrongs, to give the judiciary a chance to check the other two arms of government, or even to give Parliament a chance to review some of their legislation. We've had a lot of important legislation in different jurisdictions in Africa that has been greatly influenced, legislative reform that has been greatly influenced by public interest litigation. Just recently in Uganda, we've had litigation that has that is talking to the legitimacy and the ability of the court martial to try civilians, and that is something that's hot on the press right now. We also have had different forms of public interest litigation that have dealt with the issues of the rights of peoples, especially statelessness, the issue of statelessness. We've had the issue of female genital mutilation, I think in the Eastern Horn. We've had certain issues that were dealt with in the divorce law, led by FIDA, by some litigation in FIDA. Very proud of some of smoking that happened in Uganda some years ago. But one of the things we know for sure is that we do not give public interest litigation the importance sometimes that it deserves. We have a precedent in this country, I think in one of the courts, where it was decided that public interest litigants should not be awarded costs. And I think this declined some of the interest in public interest litigation. But today we're going to hear from the very best. We are going to hear from everybody that, a lot of people that have been in the, who have been down there with boots on the ground using public interest litigation to execute. We're going to hear from the executive how they take advantage of the rulings to make sure that they bring about the reform they need. We will hear from legislators. We'll hear from the judiciary themselves, how they think lawyers can better use public interest litigation, better come before them and use the opportunity that they're given to right the wrongs through this pill. But we're also going to hear from the practitioners, the ones that have been down there and what they've experienced, and how nations, especially in Africa, can strengthen the regional courts, can strengthen the African Court of Human and People's Rights, to make sure that it's legitimate, it makes a difference. And we also, as practitioners, ensure that we plug the gaps. I'd like to proceed without further ado and invite our first speaker, First of all, I said that this is in partnership with the Pan-African Lawyers Union, and I'm very proud to say that the Fidelis Leadership Institute has existed for about 4 years now, and we seek to support and strengthen the capacity of individuals and organizations to lead ethically, to make a difference, and to transform society. And as far as the law is concerned, and as far as our public interest program is concerned, we seek to strengthen institutions and individuals, their capacity to litigate, their capacity to identify issues, their capacity to lobby and advocate for the right things to be done, but also to provide a platform to showcase those that have done well, showcase challenges so that policymakers can address them, and also provide a critical mass of ethical lawyers that will transform Africa. Thank you very much. I'm very proud to invite Mr. Donald Dare, who is not right now going to make his presentation, but just give an opening remark on behalf of our partners, the Pan-African Lawyers Union, of which I'm very proud to be a member. Donald Dare is the Chief Executive Officer of the Pan-African Lawyers Union. He chairs the executive committees on the Pan-African Citizens Network, the Stop the Bleeding Consortium, Financial Transparency Coalition, and International Coalition for Responsibility to Protect. He is a current steering committee member and former chair of the African Court Coalition. He is also a former secretary of the African Forum of the International Bar Association. He is a former member of the executive committee of the International Institute of Law Association of Chief Executives. Being an advocate of the High Court of Kenya, he was previously the CEO of the East African Law Society, and before that he acted as the executive director of the Kenyan section of the International Commission of Jurists. He has also served as the deputy CEO of the Law Society of Kenya, and he's known for having founded the East African Civil Society Organizations Forum while serving at the ELS. As a prolific litigator, we have seen him making sure that he represents Africa in different African courts and tribunals. He has been engaged in several advocacy fora with organizations like the AFDB, the African Legal Support Facility, the Common Market for the COMESA, the International Conference on Great Lakes Region, IGAD, SADC, amongst others. At Palu, we know him as one of our champions. Right now, he's fighting many, many wars on behalf of Palu at the African Court and other regional courts. Welcome with me, Mr. Donald Dare, CEO of Pan-African Lawyers Union.
Thank you very much. To the Honorable Mr. Justice Richard Butera, Deputy Chief Justice of the Republic of Uganda, the Honorable Mr. Kiriowa Kiwanuka, Attorney General of the Republic of Uganda, my sister and comrade in arms, Ms. Linda Kasonde, who has led us impeccably over the years at the Law Association of Zambia, the Southern African Development Community Lawyers Association, and the Commonwealth Lawyers Association, to our esteemed Professor Ben Twinomugisha, to our co-host and our moderator for the day, Fiona Wall, Senior Counsel, all protocols observed. Please allow me to convey the apologies of Mr. Kari Abdul Bagi, President of the Pan-African Lawyers Union, who had confirmed to join us today from Yaoundé, Cameroon, but who is now indisposed and has asked me to step in for him for these welcome remarks. I bring you the greetings of the entire Palu leadership. And in the course of the day, you will also hear from our Vice President for Eastern Africa, Mr. Tewodros Getachew Tulu. We celebrate the partnership that we have with the Fidelis Leadership Institute, which is led by Ms. Fiona Wall, SC, who also happens to be the Secretary General of Palu, among other things. Palu treasures the strategic partnerships that it enters into with sister institutions, that help us to serve our members and to serve the African public, especially through initiatives for capacity building, for lawyers, for law firms, for lawyers associations, for citizens, but also the opportunity to just engage in networking and forge collaborations with which we can work together. And our partnership with Fidelis is one such initiative. PALU, for those who may not know, is a dual membership organization. So we have institutional members and we also have individual members. So the regional lawyers associations, such as East Africa Law Society, and the national lawyers associations, such as Uganda Law Society, are institutional members. And any individual lawyer who wants, any individual lawyer from Africa or from the African diaspora can seek to be an individual member of PALU. And to date, we have over 1,500 such members, including 5 special endowment members and about 130 life members. So we invite you, those of you who are lawyers or interested in the law here, to consider joining us. PALU works through several committees, task forces, fora, and working groups, which are arranged along our 3 sections: the section on business law, the section on legal practice, and the section on public interest and development law, SPIDEL, which is where this activity falls under in terms of PALU. So we welcome you not only to join PALU, but to look for a committee that's an area of your interest or an area of your expertise or specialization, so you can meet fellow colleagues and jointly, build your capacity, network, explore collaborations, and so on. We also welcome you to our annual conference, which is our big event of the year, where we bring lawyers and friends of lawyers together from the corporate sector, the business fraternity, from civil society, academia, and also from our governments. This year it will be held in the last week of June in Abidjan, in Côte d'Ivoire, Ivory Coast. Among other things, we will be taking African lawyers to the African Development Bank and bringing the African Development Bank to its various stakeholders. That being said, I thank you all for being here today, and I look forward to a fruitful morning of information sharing, inspiration generation, and explorations of how we can work together to make Africa a better place and to make our entire world a better place. Thank you very much, and over back to you, Ms. Fiona Wall, SC.
Thank you so much, Don. We are right on time, and I'm really glad to see a lot of members around. I would like to just recognize members from the different law societies. I also see members of the judiciary here. I would like to welcome everybody that I see online and thank you all for making the time to be here to have this important conversation. The East African Court of Justice has been meeting in Kigali, Rwanda, and we've had some interesting developments coming from there. But one of the challenges that the East African Court of Justice and other regional courts have been having, because these are some of the courts, these are some of the platforms where public interest litigation comes to life. One of the challenges that has been happening is that, of course, the nations that are signatories to the formative instruments of these courts sometimes delay in prioritizing and sending resources. So we've had, for instance, the ESCJ miss a lot of meetings. And I think one of the things I'm going to hope to hear from some of our people today is how do we improve this? I want to recognize some members online. I see the Insurance Regulatory Authority being represented here. I see Mr. Njenga. I see the judiciary. We have their worships. I think I see a lot of members of the judiciary here. I also see members from PALU, especially the Ethiopian Bar Association. We were supposed to have their president, but he is involved in a court matter as we speak. I just wanted to also let you know that as we wait for the Honorable, the Attorney General to give his remarks, I wanted to let you know that we, as the Fidelis Leadership Institute, we believe in partnerships. And one of the things that we've done is we've explored partnerships with the people who do things well. We do not want to reinvent the wheel. And one of our very good partners, I see some of them here, is the COMESA Competition Commission. And the COMESA Competition Commission has partnered with the Fidelis Institute to grow the capacity of professionals and business people in the East African region in competition law and regulation and consumer protection. And in doing this, one of the things that has happened is that we're having a lot of training of trainers that are happening, and we shall have a very exciting we'll have a very exciting calendar that is going to happen this year, starting with a training in Dubai in April for different directors on competition law and consumer protection and cybersecurity. We will also have an arbitration and dispute resolution training for October 2025 around dispute resolution training specifically for trade matters. We're going to have a regional conference on competition regulation and consumer protection, which will be in Uganda, Kampala, between the 11th and the 13th of June 2025. We also have a masterclass on legislative drafting and intellectual property slated for November 2025. We have exciting programs that are coming up with some of our partners. We see FIDA Uganda here. We see Palu, we see, of course, without forgetting a lot of members here from the Commonwealth Lawyers Association, and we're looking forward to making sure that when we deal with training as a Fidelis Leadership Institute, we're actually equipping professionals to make a difference and to transform their society. As the Honorable Attorney General also comes along, I just wanted to request one of our members who comes from the Commonwealth Lawyers Association to just say hello. She will speak to us later, but I just wanted her to say hello as former Vice President. She served us very well in many fora, all the way from Zambia. Linda, can you just say hello to everybody here? They'd love to hear from you.
Good morning, distinguished guests, ladies and gentlemen. It's an absolute pleasure to be here. I have actually just finished my term as Vice President of the Commonwealth Lawyers Association, but it is a very proactive organization that promotes the rule of law across the Commonwealth. So I would encourage all of you to look into becoming members. It's an absolute pleasure and honor to be here to speak to one of the topics that is an absolute passion of mine, and I look forward to sharing my thoughts with you on the subject. Thank you very much to all of you.
So we are expecting the Attorney General at any moment, but I wanted to proceed, I think, and start with some of the presentations. And we are going to start with the presentation from Mr. Donald Dare, the CEO of the Pan-African Lawyers Union. He is talking about using public interest litigation as a tool for socio-economic transformation for Africa. Having practiced, I've already read his very, very, very elaborate CV. Having practiced all over Africa and in the different regional courts, I think that we will benefit a lot from his wealth of experience. Donald, I'd like to invite you to make your presentation.
Thank you very much once again, Fiona Wall SC. I'll try and make a few remarks, hoping that really what we do is save enough time for an interactive discussion between colleagues, which may be more meaningful because then we might address more accurately some of what you're aspiring for, you want addressed today. And yes, while acknowledging that all human and people's rights are equal and indivisible, all civil rights, cultural rights, developmental rights, economic, political, and social rights, they're all important. I would like to lay a special emphasis on economic, social, and cultural rights today, just because there's often insufficient focus on them. And part of this insufficient focus relates, for those of us who are lawyers, even from how we're trained. We ended up with systems which privileged civil and political rights. Yet for we, especially as Africans and people of the global South, what is really important to us is our economic, our social, and our cultural rights, how we lift our people out of poverty, and how we give them a life of dignity and a life free from want and a life of hope. And to just step back and say that we live in unprecedented times. On the one hand, we have universal and regional declarations of human rights, and we have a global consensus on the binding nature of international human rights treaties and the legally binding commitments of almost every state in the world to them. That's on the one hand. Yet at the same time, we live in a parallel reality where there is a universal failure of the global order and of our governments to be able to fulfill their human rights commitments, especially those of economic and social rights. And the strongest point of this failure is the inability of our political actors, or the failure of our political actors to bridge the largest wealth gaps that have ever existed in human history. Measures, of course, have been taken to try and bridge this. We had the Millennium Development Goals. We now have the Sustainable Development Goals at the level of the UN, and the level of the AU, we have the Agenda 2063, which is our continental blueprint, listing all our aspirations and the various programs, projects, and initiatives we undertake to fulfill them. But we're still lacking. And these circumstances, especially in the context of countries of Africa and the global South, are not just born from the personal deficiencies of leaders that we may have had or Africans to manage their affairs, but in fact, they're manifestations of deep, deep patterns of historical prejudice, exclusion, exploitation, and the fundamental denial of our human rights, stemming from the period of chattel slavery, through colonialism, through neocolonialism, apartheid, and modern forms of variation of iniquities in the global order. And it is for one of these reasons why, it is for these, among other reasons, why the theme of the African Union for the year is reparations for Africans and persons of African descent, wherever they may be in the world. So it is in this area, these gaps of institutional powers, these inabilities of the governments as we currently have them, this inability of the global world order as we currently is to meet the needs of the millions and billions of people of the world, that we insert the role of lawyers, lawyers associations, and other law-based institutions to begin to make an impact. And we look at the judiciary, one of the three arms of government. As I frequently tell people, in our constitutional order that we have bequeathed ourselves, I do know something about the constitutions of the East African Community Partner States, especially Tanzania, Kenya, and Uganda. But I also do know the commitments that all African states made for themselves in the African Charter on Democracy, Elections, and Governance. We say that we have three arms of government, and the judiciary is one of the three arms of government. Many people call it the third arm of government, but I always reiterate, it's one of the three, not the third. It is not any lesser. That is why we then learn to see how to use the courts to engage our governments in a continuous dialogue of progressively improving the human and people's rights of our people. So the principle of progressive realization of rights is important. Our states started out as small and weak and with little money, and they face lots of challenges in the world order, so they cannot do everything overnight. But we have a very conscious dialogue around progressive realization, especially of economic, social, and cultural rights. And we do this in national courts and tribunals, because many times people forget that there are many tribunals at the national level, not just a formal court system. And a lot of human rights work, especially economic, social, and cultural rights work, can be done in labor tribunals, at the National Human Rights Institution, and so on. But we also do this in regional courts and tribunals. For instance, for us in the Eastern African region, we have the East African Court of Justice, which has been quite dynamic in responding to the aspirations and the requests of the people of East Africa on various issues of rights. And again, I always remind people that don't blame courts for the cases that end up before them. Judges don't file cases. It's litigants who do, litigants and their lawyers who do. So it is them to thank and them to blame, if there's such a thing as blame, around cases that have been filed. But we also have in Africa a third layer, which is a continental layer, which again also has what we call the African human rights system. And we have the African Court on Human and People's Rights in Arusha, in Tanzania. We have the African Commission on Human and People's Rights in Banjul, the Gambia. And we have the African Committee of Experts on the Rights and Welfare of the Child, which is in Maseru, Lesotho. And sometimes people tend to forget that it's also a quasi-judicial tribunal that focuses especially on the rights of children in Africa, on Africa. So over the years, we've had a range of experiences, and a wide range of colleagues have had a range of experiences trying to litigate and getting successful decisions around various economic, social, and cultural rights in these courts and tribunals. So around the rights of indigenous communities, for instance, their rights to land, their rights to their culture, their rights to live life the way they want, and their rights for the government to serve them where they are, how they are. We've got very elaborate decisions such as that affecting the Ogiek community, which was decisions of the African Court on Human and People's Rights in Arusha. We do also have the rights to land and the rights to culture and so on of the Maasai community in Tanzania, where we have a range of good decisions from the East African Court of Justice. There have been decisions around extractivist mining and its interaction with human and people's rights, and especially where there is violation of rights during mining and a failure to sustainably manage mining wastes and restore the affected areas to allow for proper communal use. So we have cases such as the Ogoniland case from Nigeria and the Mosop case from Nigeria, both of which were decided at the African Commission on Human and People's Rights. There are now issues being litigated around the responsibility to protect and safeguard rights intergenerationally. So not just the past, the present, but also the rights of future generations that might be affected by adverse and negative impacts, for instance, of climate change. So at the moment, PALU, working with a range of stakeholders from across the continent, are working towards requesting for an advisory opinion on climate justice and the obligations of states to guarantee intergenerational rights. And will likely bring this before the African Court on Human and People's Rights. So not to take too long, but just to give, that was just to give a snapshot of the range of rights that are being litigated. We recently had from the African Court a very good decision on the rights to persons with albinism, to protection and to effective protection from their states. And to say that the best public interest litigation is where there are partnerships. Public interest litigation is not a lone ranger enterprise. And if you find yourself doing it alone, they really ask yourself whether it is really public. So it's best to have partnerships And it's best to have partnerships between lawyers and non-lawyers, because public interest litigation is more about winning in the court of public opinion than winning in the court of law. It's about engaging the public to be able to examine itself, to look at how it does its things, and to look whether it's good enough, and to call for changes to laws, changes to policies, changes to strategies, changes to budgets, because you'll not achieve economic and social rights if it is not properly in the budget for it to be done. So let's consider more the kind of partnerships we can engage in across the country, across countries, across regions, and even sometimes across continents, to progressively work towards a better life for our people. Please allow me to stop at this point, Honorable Moderator. Hopefully it will allow more time for interactive debate later on in the webinar.
Thank you so much, Donald. Members that have questions, I would like to request that you, I'd like to request members that have questions to put them in the Q&A. Donald, you've given a very interesting statement, and someone said that that if you want to go fast, you can go alone, but if you want to go far, you go together, you know. And partnerships, the importance of partnerships, but also the importance of motives when we think about public interest litigation. One of the things that we've seen with some of our public interest litigation practitioners is the lack of resources and the lack of support. And then we've seen some public interest litigation that seems to be intentionally, you know, funded and well aligned and well facilitated. So I think as Africa, we also need to drive the agenda on the kind of public interest litigation that is being done in our courts. And I'm now very happy to state that we have our keynote speaker, Honorable Chiriwachuanka, the Attorney General, the Honorable Attorney General of the Republic of Uganda. We all know this gentleman as a prolific litigator who was admitted to the bar many years ago and holds a Bachelor of Laws on a degree from Makerere University, a postgraduate diploma from the Law Development Center Kampala, and a Master of Laws degree in Petroleum Law and Policy from the University of Dundee. He served as a member of the inaugural board of the Petroleum Authority of Uganda and was reappointed and just before he took up the position of Attorney General. He was also a member of the Makerere University Council, and as a council member, he served as chair of the audit committee and a member of the appointments board. He also chaired 2 search committees for principals and deputy principals for various colleges. He is a member of the Chartered Institute of Arbitrators and an insolvency practitioner, and he is also a notary public and commissioner of oaths. But a few years ago, this all became very hard for him to practice. Advocates. His far-reaching and efficacious experience in litigation in the East African Court of Justice, as well as all of Uganda's courts of judicature on behalf of both the government of Uganda and the non-state sector before that, complemented by his undertakings as an advisory technical resource across the continent and beyond in numerous sectors and subsectors, gives the Honorable Attorney General an exceptional perspective and strident intuition that uniquely positions him as an effective litigator, advisor, and negotiator, both domestically and internationally. And somebody who has participated, now he's the Attorney General, so he's actually effectively in the executive. And he's here to speak to us about how the executive can use public interest litigation to drive socio-economic transformation. Honorable Chiriwachuanka, you're very welcome.
Thank you. Thank you very much, Fiona. All our listeners. First of all, I must apologize for coming in late, but I did send my apologies. I got stuck somewhere, so my sincere apologies. I came in when Donald was speaking, And I think there is going to be a problem because I think Donald looked into my briefcase when we were in Kigali and was able to see my notes for this webinar. So I'm really, because he has said much of what I wanted to say, I'm going to try and summarize what we are talking about here. First of all, we must get a clear understanding of what public interest litigation is. And really, it is one, we are clear about the litigation part of it, but it must be a matter that affects the rights of the public generally, or a very large part of the public. It does not relate to specific individuals or groups, but not to say that a dispute or a litigation involving an individual cannot affect the rights of many people. You will find cases where one individual goes into litigation, and because the decision affects very many people, we tend to think about that as public interest litigation. So public interest litigation must be that litigation which is taken purposively for the purpose of the interests of the public. So this kind of litigation is not necessarily adversarial in its nature. It's not a matter between the state and the individual. Because the fundamental part is that the fundamental duty and responsibility of the government is to take care of the interests of its citizens. And now, once these citizens come in and say to the government, you are not doing this right, the citizens may use the public interest litigation to get the government to challenge the government on some principles that they think that they have been deprived of, or some vulnerable section of society or community, and to ensure that to assure them of the social and economic justice. So it's not really adversarial in nature. This public interest litigation is justified on the social contract theory. It is, I have a contract between government and the citizen, and this is where the obligation for public interest litigation comes from. A litigant comes up and says, you as government owe me this responsibility, which responsibility you're not properly undertaking or effectively undertaking, hence the public interest litigation. So this is a way, public interest litigation is the kind of litigation that is used to hold government to account on the principles that a citizen feels have been reneged upon. In Uganda specifically, public interest litigation is premised on really Article 50 of the Constitution. And Article 50 is where any person or organization or group of people may bring an action against another person or group of persons. This public interest litigation under Article 50 is also you can also commence public interest litigation under Article 137 of the Constitution, where you are alleging that a particular provision or principle of the Constitution has not been adhered to. So how can the executive leverage on public interest litigation to drive socio-economic transformation? And these are the ways that I think this can be done. You can get it through policy reforms, through advocacy. You have cases, we have, for example, the case on government budget on health, that is Center for Human Rights and Development versus the Attorney General, where the Constitutional Court found that the government had a duty to provide sufficient resources in the national budget to cater for maternal health. Of course, there will be two views on that. Are we saying that the court is now budgeting, or is it the duty of the legislature and the executive? Is it the duty of the executive with the legislature to budget? And is the court now entering into the space of budgeting? It's a balance that needs to be found. Because what the court is saying is you have this obligation, but the court does not have the pass that the executive, the extent of the past. So it's a balance. So when the court comes out and says you are not doing right, it is then the duty of the government to go back and make policy reforms to address that gap that the court has pointed out. And then you have we have cases where we have had genital mutilation, female genital mutilation, where the court found that it was an undesirable practice. Again, here you are having a large group of society which is being addressed through public interest litigation. Obviously, the question there will be, to what extent can you call the fight against FGM public interest litigation? Does it affect a sufficient number of society? That is a question that we are going to grapple with as litigants to figure out what is the extent of public interest. Is public interest a question of numbers? Is public interest a question of quality? Is it quantity? Is it how many people are being affected? Or is it how does it generally affect the society? Then you can use the law and legal framework and through public interest litigation identify gaps or deficiencies in the existing laws and advocate for legislative reform. So the court can say, no, you need to do this. The most recent one, which is alive to everyone, is the recent decision of Kabaziguruka, where the court said there are gaps in the UPDF Act and therefore you must go and deal with them. That can be public interest litigation. You can get it through public engagements. It can be a tool for public engagement. The voices and the interests of the public can be heard through litigation. A group of society may feel that it is not heard every time they make an attempt to speak to the executive about an issue that affects them. And through public interest litigation, their voices can be heard. So you can have, it can be a tool, public interest can be used by the executive as a tool for strengthening a mechanism of monitoring and evaluation of the existing laws and policy. The executive will put up the law. The legislature may agree. Public interest litigation could go out to find, for the court to find, and the court could find that whereas the law has been put in place, its implementation has been ineffective. That is another way in which socioeconomic transformation can be done through public interest litigation. Then you have the issue of social awareness. Public interest litigation can be used to arouse social awareness on an issue which may not be to which many people of the public may not be alive to. Then you have the issue of resource allocation. It's very similar to what I've just spoken to. Through public interest litigation, you can actually have the executive go through to actually determine how the resources, or the executive can relook at how it is allocating the resources, the various sectors. It goes, again, public interest litigation goes a long way in promoting good governance and accountability, and also establishing a legal precedent. Public interest litigation can be used to define legal precedents, which then guide the rest of the public on how to do it. The area that we use public interest litigation more is a promotion of human rights. You have more litigation in the area of human rights through public interest litigation, where a person comes up and says that the government is not carrying out, is infringing on the constitutional rights of citizens, and that can be addressed through public interest litigation. So in summing, I would say that public interest litigation is a resourceful tool, mechanism that can be used to protect fundamental human rights and advance the realization of national and socio-economic transformation for its people. It's very important for the executive always, the legislature and judiciary, to listen carefully to what the public has to say. And when the court makes a pronouncement, whether you like it or not, it's always important to address your mind to the principles that have been brought out. So for us, from the side of the executive, as a litigant, you will use it to advance and bring out all these issues that I have raised. The executive, on the other hand, must look at what the decision of the court has been and also find out what has been done. Now, in my position as Attorney General, obviously, I am a statutory respondent. And therefore, at all times, every issue that has been determined in any public interest litigation is squarely placed on my lap to ensure that what the court has decided has been clearly understood, one, and as far as possible, been implemented. And even where it has not been implemented, explain to the public what are the pitfalls and what are the challenges that have been met in trying to address this issue. So public interest litigation in Uganda is growing. It's welcome. The only thing that we have a challenge with is the view of public interest litigation of the public against the state. And that is the kind of rhetoric we need to take away. Public interest litigation is not adversarial. Public interest litigation is advisory. You are both coming in to put your principles across so that you can get guidance on where to go. So we need to take away from the public and the litigant that public interest litigation is adversarial, is where the public is going against the state. No, it's the public telling the government where they think they need to do better. I thank you very much for listening to me, and I think I'll sum up right there. Thank you very much.
Thank you so much, Honorable. We had that you gave quite an interesting presentation at the ESCJ, and it's really good to see that you and Don have done justice to this topic from both the litigator's perspective and the executive's perspective. You raise very important points about the quality, the impact. Again, like Don talk about the motive, and I think what we've seen all over Africa now has been that public interest litigation has been driven by three major things: NGOs and civil society organizations, and then a lot of judicial activism. But we've also seen some executive action, especially how they relate to the decisions that are made. Sometimes the executive acts very fast and implements, and we've seen that also happen all over Africa. Members, I still urge you to put your Q&As here. I would like to ask, before we go to the next speaker, we really needed to keep time. That's why we are moving a bit fast. But I would like to ask if I just want to check the Q&A. I don't see questions yet. We're going to go into a panel discussion and we'll have a lot of questions then. But I'm going to ask that if you have a question right now for the Honorable Attorney General or for Don on their presentations, you could raise your hand and perhaps ask. And I'll take only about 2 questions. I'd prefer if you put the questions in the chat. I'll allow about a minute for that before we go forward with our program. On the aspect of, again, public interest litigation, I was trying to look at some examples from Africa. They mainly seem to fall in 3 main categories: environmental protection, human rights, and access to basic needs. Of course, with the SCFTA and business rights coming up, we're beginning to have some business rights leaning litigations. But for environmental protection, we've had, I think, in South Africa, we've had a lot of cases against pollution by mining companies, petitions against deforestations in the Congo Basin. We've had that. We've had challenges under human rights. We've had challenges to restrictive laws on freedom of assembly, litigation against police brutality. We've had cases addressing discrimination based on gender, ethnicity, or sexual orientation, but we've also had some litigation that talks about the right to be heard, especially before which court, like what the Honorable Attorney General referred to. Then we've also had cases under access to basic needs, because we're still a developing continent, and the right to healthcare litigation has been seriously litigated all over Africa, especially in West and East Africa. The access to education lawsuits, that's also happening, and then the right to clean water access. these things have been litigated, and they're very good precedents for us to look for these different cases. And that is why today we brought you litigators from all over Africa, so that we enrich our knowledge. But as Don said, we will go further if we partner. So we need to see civil society work with the three arms of government to actually look into making sure that we address the gaps. There are things we disagree on, but there's a lot of things for the welfare of the African people that we definitely agree on. I do not see questions right now. Oh, I see two questions. Ronald Dennis Bukomba asks that what are those appeal cases that the Attorney General appreciates to have made a significant contribution to Uganda? That is to you, Honorable Attorney General. Judith says, thank you for that insightful discussion. My question is whether cases under appeal can be given priority over other cases. It's unfair for a case under appeal to take 12 years to be concluded by the courts. That's something probably the Honorable Deputy Chief Justice might also address themselves to. But Honorable Attorney General, I know that you'll be running for another meeting shortly. I just want to request you to address those two questions to yourself. Since Don, we'll have more questions as he does the during the Q&A. I would like to have you answer these two questions.
Thank you very much. On the first question, what are the cases that have impacted? Every time the Constitutional Court makes a finding that a matter or a provision of the law is unconstitutional, there is two things that we look at. We go back to the history of that legislation to determine what was the purpose of that legislation. And then we try to figure out what was the import of that section of the law. So once the court finds that a matter, for example, we talked about the issue of the Center for Human Rights Development and others versus Attorney General, the one that dealt with the budgeting for maternal health. The court did give guidance that provision for maternal health must be given priority. Obviously, the question then is, what shouldn't I give priority? Now, if you look at the subsequent budgets of government since that decision, you will see a lean towards maternal health in the sector of health. But the government policy on health has always been prevention as opposed to cure. So there's that balance. That was an important decision. Even this recent decision that we're discussing of Kabaziguruka, it has very interesting principles that we need to address our minds to on the issue of the fairness of the trial before the court martial. Let's first forget whether it's a civilian or a soldier. Both of them are entitled to a fair hearing. So in the view of the court, they said that you can tell us that the hearing was fair. How do we see that it is fair? And you will go through, like I said, the public interest litigation is the balance that you need to find. We, from the executive perspective, whereas public interest litigation has got this large number, we have also at least in the Attorney General's chambers, we have put a constitutional petition under public interest litigation, because we think that any check or any amendment to the Constitution is a matter of public interest. So that I hope that answered the question. On the question of the unfairness of taking time, I agree with you entirely. Not only on appeal, but also in the first instance. But the question that came is, it's unfair, and really it is a matter again of public interest. One of the principles of justice is that it needs to be speedy, fair. So, but speedy is part of the whole concept of justice. So if a matter stays in the courts for a long time, it's definitely unfair, and it's really undesirable. But the courts are doing a lot, our listeners. The courts are doing a lot to try and get this done. Recently, you know that the courts have opened more circuits around the country. The executive has provided the resources to make sure that we have more judicial officers. We know that we are supposed to have a grade 1 magistrate at every constituency, a chief magistrate at every district. We are soon going to start opening circuits for the court of appeal. So all those efforts that are being made to try and speed up justice. Obviously, the challenge we have is again the resource envelope, because as the court circuits are being increased, the number of state attorneys is not being increased from the DPP's chambers and also from the Attorney General's chambers. But I sit in cabinet, so the principle and the concept behind that was that there can be justice even without the state attorney. For example, if the police delivered someone in court, if the police arrested someone and the person was remanded in court, if the DPP is not there, then the court at least is there to figure out how to ensure that justice is done. So it's a balance that we are trying to do, and we hope that in the next financial year, more state attorneys are going to be provided to the DPP to increase on the depth of the office, and also the Attorney General's chambers. This rationalization is doing that. So I agree with you that the delay in the process is undesirable. And to be honest and clear, it is not at all the intention of the executive to do that. It's not the intention of the legislature or the judiciary. It's not the intention of government to do that, and we'll do everything humanly possible to get that done. But as I close, I just want us to, as we go through this webinar, to always reflect on the motive and purpose of public interest litigation. What is the motive and the purpose? That is a question I leave to all of you. Always remember that the motive and the purpose for which you bring the public interest litigation then determine how well it is received. And therefore, it is always important, before you even start the public interest litigation, is to engage the government. Every time I have a matter here, I always ask, why didn't anyone come to engage and say, we think this is wrong? Because then we can use the available avenue to deal with that. So we call upon all of you, the litigants, the members of the public who are listening, that if you have an issue and you think that it needs to be addressed, do reach out. And then we can be able to say, no, I reached out to you. You did not give me any convincing reason why I should not go to court. That way we could resolve some of these matters and not have to stay in court for so long. Obviously, if we are very strong on an issue, we will advise. And then at that point, the court has to be the final arbiter. I thank you. Thank you very much.
Thank you, Honorable. Just to give an example to what you've just said, a few years ago, the Uganda Law Society sued the Republic of Uganda about the issue of the Trade Licensing Act and how it was causing double licensing and double certification for professional services in the legal sector, and the Law Society won. And later on, I think that was around 2020, and you were Attorney General then, 2021. Other professional associations approached Uganda Law Society and asked them to represent them against the government again for the same reason. And I think when you received the notice of intention to conversation, and there was a consent. So I think the aspect of involving even the people you intend to sue and collaborating on some of these things might make PIL go a lot further. The way I said that together we go further. Thank you so much, Honorable Chiriwa Chiwanuka, for your presentation and for responding to those questions. There are more questions in there, and I think I see Yona Banda who asked the parameter for the human rights litigation in terms of the number of people, the call for engagement before appeal cases is really good. Well, for the issue of time, we really need to go and meet our chief guest of the day. And I'd like to thank him for coming because, as I said, one of the biggest pillars of public interest litigation in Africa actually has been judicial activism. And we have with us the Honorable Justice Richard Butera, the Deputy Chief Justice of the Republic of Uganda and the head of the Court of Appeal, which also sits as the Constitutional Court of Uganda. The Honorable Justice Richard Butera was appointed by the President of the Republic of Uganda to be Deputy Chief Justice and head of the Court of Appeal and Constitutional Court in September 2020. He has served in various legal institutions and held different positions. For instance, Justice of the Supreme Court from 2017 to 2020, and before that he was the Director of Public Prosecutions for close to 18 years, and he really did a fantastic job in those years, if I may say so myself. He served as a Chief Registrar of the Courts of Judicature in the early 90s. I don't know where some of the young people here were at the time. He also served as the Inspector of Courts and Discipline for judicial officers, in charge of discipline and performance and monitoring performance. He was earlier on a chief magistrate in various chief magisterial areas, has been an assistant lecturer and research fellow at the Makerere University, and he is currently the chairperson of the Case Backlog Committee of the Judiciary, charged with managing case backlog. He has over 40 years of experience in the legal profession and holds both Bachelor of Laws from Makerere University, a postgraduate diploma in legal practice from the Law Development Center, and a Master of Laws in Alternative Dispute Resolution from Pepperdine University. He also is very passionate about mediation and alternative dispute resolution, and has championed an innovation that has created mediation at the Court of Appeal, which is helping again with the case backlog. He's the member of the top management of the judiciary and sits on the Judicial Council. In discharge of his social responsibility, he's passionate about mentoring young lawyers across the country, especially in government agencies, and he's the patron of the Association of Uganda's Prosecutors. He is also known for being a good timekeeper, I will say strict, and a humble judge who administers justice with meekness and mercy. I will now I'll take this rare honor to invite His Lordship, the Honorable Justice Richard Butera. You're very welcome.
Thank you very much, moderator. Allow me to adopt the protocol. And, thank you very much for inviting me for this function. Public interest litigation does play a very important role in ensuring constitutionalism, adherence to the rule of law, and socio-economic development of a society. I'll quote the case of Reverend Mutikila versus the Attorney General. It's a case of Tanzania. And the court stated that public interest litigation describes legal actions brought to protect or enforce rights enjoyed by members of the public or large parts of it. It is litigation instituted for the benefit of the public who may be aware of their rights but lack financial ability to enforce those rights, as well as those who may not be aware at all about their infringed rights. This really defines what we are dealing with, which the Attorney General has adequately handled, but we are made to look at public interest litigation in terms of what concerns the public. It's not the lawyers, it's not the legal fraternity, it's the public and public interest that we are dealing with. In Uganda, as the Attorney General has said, we mainly handle these cases that come through the petitions under Article 50 of the Constitution and Article 137 of the Constitution. So these cases, therefore, mainly come to the Constitutional Court, which I had. I think here I need to address a question that was raised to the Attorney General about delays in handling of these cases. We are aware that the public and litigants generally have a constitutional right under Article 28(1) for their cases to be heard, and they should be given a fair and speedy trial. We are also aware that under Article 126 of the Constitution, sub-Article 2D, justice should not be delayed. We try to, at the Court of Appeal, where much of this area of litigation comes up, try and handle these cases as quickly as possible. But I would appeal to our participants to keep in the know of the position of personnel at our court. We have been having 12 justices who handle the Constitutional Court, the Court of Appeal in respect of criminal cases, and civil appeals, as well as election petitions. Now, constitutional cases are supposed to be given priority, and we try our best to do that. But this has to be done together with the considerations of criminal appeals where the appellants have been convicted by the High Court and are serving sentence. It would also be important to give them consideration that time is running when they are in a detention and might be innocent. Now, we need, therefore, to see how the court does it. We try to balance and do constitutional petitions, do criminal appeals, do civil appeals, when we have only a figure of 12 justices. But we have now, this week, had 9 justices sworn in. They are beginning work next week, and we hope work shall improve. But even with the little numbers that we have been having, 3 years ago, the Constitutional Court had over 200 cases, constitutional petitions and constitutional references. There are more than 200. We have worked hard. As I talk today, the pending constitutional petitions are only 74. We think that with the numbers we now have, before the end of this year, we shall have no backlog in respect of constitutional matters. This we are sure we can focus and do. The experience we have with the election petitions, election petition appeals can define this, that we can handle. Historically, election petitions have been lying in the Court of Appeal for probably over 5 years, but the last election cycle, we handled all the election petition appeals that were in this court in the time. I think we had a period of only 4 months. We put our foot together. We did not allow adjournments. We started on time, and we concluded election petitions in time. What the few that are now pending are actually resulting from petitions that were concluded. Cases went back for re-election, and the appeals are back with us. That answers the question that was raised on delays. But in respect of the importance of public interest litigation, let's speak on a few cases that show us what has been happening. In Uganda, the areas that are mainly litigated are healthcare, environment, cultural issues, and the rights of citizens. If we take on cultural issues, we have the case of Salvatore Abuki versus the Attorney General. This is a case where Abuke had been convicted for practicing witchcraft. He was sentenced to 22 years imprisonment. And in addition to that imprisonment, he was banished from his home. The Constitutional Court handled this matter, and the Witchcraft Act provisions of it that were found vague and ambiguous were declared a nullity, and the exclusion order was declared unconstitutional because it was declared unconstitutional because it threatened the petitioner's life by depriving him of the means of subsistence and depriving him of access to his property and denying him the right to be in contact with his relatives and friends. This was a private citizen endeavoring to lead a decent life. And these are cultural norms and legislation that deprived him of these basic rights. So issues of development are also addressed in this. We can also look at the case of law and advocacy for women in Uganda versus the Attorney General, which was in respect of the Divorce Act then. And the Constitutional Court did declare provisions of the Divorce Act to be unconstitutional for treating different sexes differently. So these are issues of equality before the law that were addressed there. You can look at the case of Amot Geoffrey Nyakana versus the National Environment Management Authority, which was a case concerning the right of Nyakana to own property, which he owned in a wetland. The NEMA, National Environment Authority, gave him a restoration order, failed to obey it, and his unfinished building was demolished by the authority, and they took this to the Constitutional Court. Now, the Constitutional Court did declare that he had the right to own property, but the use of that property should not be in infringement of the environment. So there was a balance to be made between the right to own property and protecting the environment. If we looked at the case of Mifumi versus the Attorney General, it was on bride price, again, issues of cultural conflicts with the law and the rights of citizens. And now the Kabaziguruka case that is new, which was really a consideration of the right to a fair hearing. The simple question was whether civilians should be tried in the military court martial. The Supreme Court has now finally settled the matter that no civilian should be tried in a military tribunal. This is a very important decision on human rights, on the rule of law, and important issues that should be settled, and people come to do their other work and live in harmony. On the whole, I would say that public interest litigation is important for protection of people's rights, enforcing those rights, getting the public to know their rights, getting the lawyers to participate actively, getting the attorney generals, the courts, all to work together and protect public rights. I would summarize to say that the importance of public interest litigation to all of us is clear. I therefore take this opportunity to declare this webinar officially open. I invite all the participants to actively engage in the discussions, share their experiences and insights. Thank you very much.
Thank you very much, my Lord. You've really done a fantastic job of giving us actual cases and how they address these issues. but also brought to light a lot of areas in which the different members of the judiciary, the law society, the legal fraternity, and even the executive can take on this aspect. I'd like to invite people, if they have any questions for His Lordship, I can put it in the Q&A. I think for me, Honorable Justice, we have a rich, should I say, a rich history of public interest litigation in the Court of Appeal in Uganda and other courts of appeal all over the world. Sorry, other constitutional courts. But sometimes there is a lag between the time that decisions are made, especially decisions that are meant to reform legislation or practices, and the time that it is actually implemented. There's also been some public interest litigation, I think you've mentioned some of it, that talked about, for instance, the death sentence, leaving someone on death sentence beyond a certain period without executing them, and how it mutes to life. That was a very important decision, but then it creates other problems as well. So how would you state that the role of judicial activism could come in here, or the collaboration that the Honorable Attorney General is talking about could come in to address some of what I would call the problems that are created when we have only one aspect, because appeal is a whole process. There's the preparation for it, there's the actual litigation, there's the decision, and then there is the implementing of the decision. Where do you think would have more impact working together to touch as the legal fraternity and the judiciary?
I think on this we need to do training for the lawyers and training for judicial officers. It's an area of capacity building, because sometimes we have had cases where the point being raised in the petitions is not brought out clearly with evidence. And it is the duty of the petitioner to provide the evidence that will help the court in resolving the issue. But you can see that there is an issue of capacity for the lawyers. Sometimes also there is an issue of building capacity on the bench. So I think one area we need to build to work on together is training.
Thank you very much, my lord. We would like to take just a poll as I wait for more questions. If you have questions for His Lordship, you can put up your hand, or you can actually set your questions in the Q&A tab over there. So members online, I'm happy to see a lot of you here. I would like to request that we take a short poll on the impact of peel in Africa. We have a few minutes, so please just take this time and answer. Would like to see what's happening. The poll is online, just answer. In your opinion, which area has peel made the most impact in Africa? Human rights and constitutional freedoms, environmental protection and climate justice, access to justice for marginalized communities, government accountability and policy change. Lawyers, this is your opportunity to contribute to data, so that after this we'll release the results of these polls, and hopefully they'll say a lot about the areas where we need to increase our efforts. At the same time, I'm expecting questions for His Lordship from his very elaborate presentation. My Lord, we will reach out to you to ask for the presentation so we can send it to our members. It's akin to a serious lecture, and thank you so much for that. And we're very honored to have you here. Yes, I still need more respondents to the poll. Members, please look at the poll and respond. In your opinion, which area has Peel made the most impact in Africa? We have human rights and constitutional freedoms, environmental protection and climate justice, access to justice for marginalized communities, and government accountability and policy change. At the same time, I would like to ask His Lordship, as the poll goes on, in your opinion, where do you think there has been the most impact by Peel?
Sorry, if you could repeat that again.
I was asking,
Would you repeat the question?
sorry, in your opinion, which area has public interest litigation made the most impact in Africa? Is it human rights and constitutional freedoms, environmental protection and climate justice, access to justice for marginalized communities, and government accountability and policy change? We just wanted to hear your opinion of this, my lord. Have you heard me, my lord?
I have heard you.
Yeah.
I'm saying the areas that have been litigated upon mainly are in the area of environment, on human rights. And now what is coming up that is growing clearly is also in the area of health rights. They are the main areas.
And where do you think has been the largest impact, the greatest impact?
We have seen, you talked about the death sentence. We have had legislation incorporating the proposals of the Supreme Court. We have had legislation in the areas of protection of accused persons in aspects of remand and remand periods. I think generally public interest litigation causes government to react and take up legislation following court decisions. So the more that comes to the courts, the more will be taken up by the executive and the legislature. So the two
Thank you
tend
so
to react.
much. My lord, there is actually a follow-up question here, that what are the parameters used to measure the impact? Is it just when somebody wins, or is it important just to even have the matter decided upon? That the you know, sometimes Lord Denning was known for not always being the one leading, but even his dissenting opinions became, you know, some important precedents. So the question says, would the wins aptly capture the impact of Peel, or is sometimes the fact that this has been litigated upon also important enough, in your opinion?
We have seen areas where I mentioned that we have had sometimes to dismiss a petition, but when you look at it, you find that if the lawyers had been better trained in the area of public interest litigation, probably they had a point that they failed to articulate by gathering evidence adequately to present the petition in a better form. But then the court cannot petition for you or improve your petition, so it has had to dismiss it. But the Attorney General has been in court. The area of concern, therefore, is raised, and the executive will pick interest. We had a recent case in public health care issues that I think the Attorney General did win on the technicality, but I think they will take up the issue because it was raised. It could have been better litigated, but the matter would be taken up. So taking it up properly is important, but taking it up initially is equally important.
Thank you, my lord. I think you make a very good point on training and purpose. I think also motive and preparation. You know, preparation is everything. Somebody, Judith Nasubuga, asked earlier that whether cases under public interest litigation is there where they can be given priority over other cases sometimes because of the kind of impact they have and because it's far-reaching as opposed to individual cases. Of course, we know that individual rights sometimes people's lives are at stake. But in your opinion and in the work that you're doing also, how is the Court of Appeal, for instance, prioritizing some of these matters because of the amount of impact they have?
Yeah, I explained that we do take this seriously, but I also added on the fact that we have now 9 new judges. We have reduced constitutional matters pending before the court from 200 to only 74. Of these, only about 40 are backlog. And we think we can do this in the next half of the year. And by the end of this year, we should have no backlog on constitutional issues. By the end of the year, therefore, beginning next year, we should be handling constitutional issues to a great extent as they come to court. Priority has been given to constitutional issues. The problem has been numbers. The numbers are rising. We think with this 9, if we get an addition to this 9 in the next financial year or this financial year, we shall not have any backlog on constitutional petitions in the Court of Appeal, Constitutional Court. And I think that will solve the issue of do we give priority to the constitutional cases? Yes, we do.
Thank you so much, my lord. That is very good news, and many people must be excited. I think Akira Brenda in particular, who had asked a similar question. My lord, I want to share the result of what the members online thought about the impact of PIL in Africa to see if it reflects. And so far, we had 38% stating that human rights and constitutional freedoms is where PIL has made the most impact, followed by access to justice for marginalized community and then environmental protection. So government accountability and policy change is down there. And another aspect that you spoke about was health. We hadn't put it in our poll, and also I would say trade and business rights. We've seen a lot of non-tariff barriers despite the common market protocols that are being signed. So this is an area that I think is a developing area for lawyers to get into in form of PIL. There are the Honorable Justice, the Honorable Deputy Chief Justice of the Republic of Uganda. We thank you so much. I want to ask everybody to, share your comments and compliments. Thank you, my lord, for being a guest of honor. Thank you so much for giving such a fantastic keynote, and I hope that we'll be able to share. I want to pledge that we'll be able to share that presentation with everybody that has registered for this webinar. And we want to commit that as the Fidelis Leadership Institute, even as PALU, we shall continue facilitating our members to carry out public interest litigation that is fundamental to transforming the socioeconomic state of the people of Africa. And one of the things we're doing is raising awareness through webinars like this. So thank you so much. We do not take your presence here for granted. Thank you, Honorable Attorney General. Thank you so much, Mr. Donald Dare. I'm going to ask that Donald you stay. Thank you so much for giving of your time. It is not taken for granted. And the participants we have online are, we can see that we've been ranging around 100 members from all over the continent, but I also want to state that we are live on LinkedIn and we are live on Twitter as well. So thank you so much for being here, and we invite you to stay online and make comments, but we know that you're very busy and the Court of Appeal is very demanding. So I'd like to thank you very much for being here and appreciate you. I don't know whether you have any last word for us. I cannot have the last word, my lord.
Thank you very much. It's been lovely.
Thank you for having us.
Discussion. Thank you.
Thank you for having us. Wish you great deliberations going forward. The Attorney General's Chambers remains available to support in any way we can. So whenever you have an issue, please feel free to come. The public, feel free to come in, raise the issues, and we'll do our best to try and resolve them. I thank you.
Thank you very much. Thank you very much, Honorable Attorney General. Thank you very much, our Honorable Deputy Chief Justice. So going forward, we are now going into our panel discussion, and I'm very excited to invite and introduce our panelists. But before that, I would like, as I invite you all to stretch, our panel discussion will just take a little less than an hour, so please be patient with us. And for that panel discussion, we're going to have Mr. Donald there, who already spoke. We shall have Professor Ben Twinomujsha, who is a senior researcher at AFIA, Nahaki, and the former Dean of School of Law, Makerere University. We, his former students, and I know many of us are here, knew him as Shokoro. It was a very infamous nickname. I don't know how he had it. I was as I think one of the younger versions of his students, so I wouldn't know the history, but we really loved him for his frankness, for his forthrightness, for his passion about especially public interest litigation around health. And he's the first Doctor of Laws degree graduate of Makerere University. He has previously worked in the Ministry of Lands as a lands officer way before he became a Don at Makerere. He also worked in the National College of Business Studies as a lecturer. He practiced law with Sam Kutesa and Company Advocates and Twinomujsha Shokoro and Company Advocates. He has more than 30 years of experience in academia and legal practice in areas including commercial law, public law, as they pertain to issues of international and domestic law. He has taught and examined several universities in the region. He has also published in the areas of environmental law, gender, health, and human rights. He has recently published a multidisciplinary book, Fundamentals of Health Law in Uganda. This was some time back. And Professor Ben has had several views on governance of Uganda, women and sexual reproductive health rights, and he has contributed to many research studies. He's also the chairperson, Board of Trustees, CEHAD, or Center for Health, Human Rights and Development. Welcome with me, Mr. Professor Ben Twinomujsha, our favorite lecturer, Shokoro. Please welcome him. Okay, as he comes on, I'd like to invite to also speak to our other panelist, a friend, somebody that I've known for a long time who served in the Uganda Law Society. She was working in the People and Human Resources Department, and she's also done many other things, but right now she is Lilian Agwang Emilu, the Acting Executive Director, Center for Public Interest Litigation. Lilian is a passionate and dedicated human rights activist committed to promoting justice, equality, and dignity for all. She's driven by a deep belief in fundamental human rights and advocates for marginalized communities and works to challenge systemic inequalities. Her experience encompasses research, advocacy, public awareness campaigns, and community organization by empowering individuals and groups and creating collective action to drive positive change. Lilian strives to amplify the voices of vulnerable communities and contribute to building a more just and equitable society. She wants to collaborate with diverse stakeholders, including NGOs, government agencies, and international organizations in her efforts. And I want to state that at the Center of Public Interest Litigation, they're also growing the capacity of what appeal looks like in Africa, in East Africa, and in Uganda in particular. Liliana Gwang, you're very, very welcome. I'd also like to introduce another eminent person who I had earlier on had speak to us. She's served in very many capacities. Another friend, mentor, and activist extraordinaire, Ms. Linda Kasonde. She is a partner, and she's coming in all the way from Zambia, of LCK Chamber. She's the founder of it. She's also the founder of Chapter 1 Foundation. She was admitted to the Zambian Bar in 2001 and holds an LLB law from the University of Leicester and an LLM from the University of Cape Town. She is a lawyer and civil rights activist who is the immediate past vice president of the Commonwealth Lawyers Association. Prior to setting up the chambers, she worked in one of the most well-recognized commercial law firms in Zambia for 15 years as named partner. Her current practice centers on general dispute resolution, human rights and constitutional law advocacy, and strategic and public interest litigation. She's a member of the Chartered Institute of Arbitrators, and she is the first woman to be elected as the president of the Law Association of Zambia in the history of the Bar Association of Zambia. I hope the ladies here are sending her flowers. Linda has written a memoir called Women, Resilience, and the Will to Lead. This was about her experience as a woman in leadership in Zambia between 2011 to 2021, trying to challenge creeping authoritarianism in Zambia. Linda has undergone several leadership fellowships and programs, including at Stanford University, the Archbishop Desmond Tutu Leadership Fellowship, the U.S. State Department's International Visitor Leadership Program, and she was listed on the Courtroom Males Africa's most influential women in the legal professional list. She's also won the Woman in Law in South Africa Awards, as she was a winner for Best Pro Bono Human Rights Social Justice Lawyer. She has also been a first runner-up for the Pinnacle Award and a first runner-up for Best Leadership Award. The Africa Report has named Linda as one of the people to watch for 2017. She's also a former member of the advisory board of the Africa Regional Forum and the Bar Issues Commission at the International Bar Association. Please welcome with me Linda Kasonde. Next, we are now going to have our panel discussion. But before that, from FIDA Uganda, one of our partner institutions, we have Ms. Susan Baluka. And if you are a young woman and you grew up attracted to gender equality and the struggle for gender parity, I think FIDA has always been a champion for this. So representing FIDA today and representing the executive director is Susan Baluka, the manager, strategic litigation, FIDA Uganda. Susan Baluka is the manager in charge of strategic litigation at FIDA Uganda with 9 years worth of experience in litigation and advocacy for rights of marginalized communities in Uganda, including advocacy around women's economic justice, violence against women, and sexual reproductive health rights. She's also a member of the East African Women Human Rights Defenders Network, where she represents Uganda on the network steering committee. Susan, you are very, very welcome. I'd like to start with Ms. Linda Kasonde. Linda, please give us just a presentation on this theme, on how we can use public interest litigation for the socioeconomic transformation of Africa. And I'll give you 5 to 7 minutes for your presentation, and then we can move on to then we'll follow up with some questions and then move on to somebody else. Thank you.
Thank you, Fiona SC. And it's an absolute pleasure to be here, as I mentioned earlier. I just want to thank the Honorable Deputy Chief Justice Butera, the Learned Attorney General, Senior Counsel Don Dea for their wonderful presentations. It's good to see public interest litigation so positively received, especially in the public sector. So in terms of the wins and challenges and the journey ahead for Africa, I would like to just talk about my own personal experience with public litigation. I consider myself an activist and a human rights defender. And as you know, earlier highlighted, public interest litigation is a critical tool in the toolbox of any human rights defender. And it can be used to ensure that the social contract between governments and their citizens is enforced for the public good. And it requires an active citizenry or civil society, and equally important, an active and socially attuned judiciary. And this relates to the promotion and protection of socio-economic rights, as well as the more traditional civil and political rights. So I believe that public interest litigation can be most effective when it succeeds and is enforced at the domestic level. And this is because often there's a lengthy period of time that it takes to conclude cases that go to regional courts. And also there's the added advantage of having a domestic remedy. However, as I will discuss later, in some cases, it's absolutely necessary when one is not able to get an effective domestic redress or remedy. Regarding socioeconomic rights, one case that had a huge impact on its society is the South African case of the Minister of Health and others versus Treatment Action Campaign and others. Regarding, well, the case arose at the height of the HIV/AIDS pandemic in South Africa, where the government refused to provide the drug nevirapine in public health facilities. And that drug was supposed to be given to newborn babies to prevent mother-to-child HIV infection. So not only did the court determine that nevirapine should be provided in public health facilities, but also ordered that milk formula should be provided to HIV-positive women to further prevent mother-to-child infection. So that you can see that was a very sort of positive determination by the courts that had a huge social impact on the well-being of society. And similarly in Zambia, a very interesting case arose in the case of George Mwanza and another versus the Attorney General, in which 2 HIV-positive prisoners on antiretroviral treatment argued that the squalid conditions in which they lived and the poor diet that they were afforded as prisoners was not conducive to their health. And after the case was dismissed at the High Court on the basis that the Zambian constitution did not provide justiciable socioeconomic rights, in a unanimous decision of the Supreme Court, the court held that the right to life meant the right to a dignified life, which included the right to nutritious food. So here we see judicial activism at play to extend civil and political rights, such as the right to health, to social economic rights in a broader sense. So judiciaries often grapple with how to address cases that involve socioeconomic rights that have budgetary implications. And sometimes there is pushback from the state that it has insufficient resources to apply the judicial remedy. However, we must always strive to ensure progressive realization of socioeconomic rights. In a previous life as the Bar Association president in Zambia, the Law Association of Zambia went to court to challenge the continued stay in office of ministers and deputy ministers after the dissolution of parliament ahead of the 2016 general elections. So the situation was that the Zambian constitution had been amended substantially in January 2016, and there was a lack of clarity on how those amendments had affected the position of the ministers when parliament was resolved. As the Ugandan Attorney General mentioned, this wasn't necessarily about fighting the government, but about clarifying the position at law. So the Law Association of Zambia argued that the constitution, which had been amended in January 2016, still required ministers and deputy ministers to vacate office on the dissolution of parliament because their positions were dependent on being members of parliament. And finally, in August 2016, the Constitutional Court found in favor of the Law Association and ordered that all the ministers and deputy ministers had to pay back the emoluments, rather the salary, the payments they had received during the time that they were illegally in office. And this was actually enforced. So it was a huge landmark case in the country, and also an example of the judiciary keeping the executive in check. I've also had the privilege of setting up Chapter 1 Foundation, which is an organization that promotes and protects human rights, the rule of law, and social justice in Zambia. Through public interest litigation, we have successfully challenged an internet shutdown during the 2021 general elections in Zambia. Now, this was a public interest litigation case because of the social and financial impact that the internet shutdown had on all internet users in the country, both at an individual and a corporate level. And maybe just to add here, so far, all the public interest litigation cases that I've been involved in have involved working with other organizations or other individuals. But this particular case required moving fast. And so as an organization, we took it up on our own. So again, that's not the desirable position, but I just have to say that in some circumstances, it is required to move fast, although the desirable situation is to work with others. And as I mentioned earlier that I personally prefer having matters resolved in domestic courts because of the sometimes lengthy process of having to exhaust domestic remedies before taking up a case in the regional court. But sometimes you are left with no option. And although justice may be delayed, it can yield very positive results in the long run. For example, in 2019, Chapter 1 Foundation and Young Women in Action challenged the failure by the Zambian government to adhere to constitutional provisions that require that the government ensures gender equity in the appointment of ministers and other public officials. So we lost the case in the Constitutional Court and have since referred the case to the African Commission on Human and People's Rights. If we are successful, it may be the most impactful decision on the right to gender equality on the continent. So you can see there that while this was a domestic issue, potentially it can have a regional, a whole continent impact. So we really wait and see what the court will say regarding this issue, and we're very positive. I hasten to mention that public interest litigation isn't always about winning. Sometimes it can work as an advocacy tool, highlighting a public injustice. For example, in 2020, Chapter 1 Foundation and the Law Association of Zambia challenged the tabling of the Constitution Amendment Bill number 10 of 2019, or Bill 10 as it became known. This bill threatened to undo the democratic gains that we had made as a country. It involved wholesale amendments to the Constitution. So we lost the case in the Constitutional Court, but we won the advocacy battle in the hearts and minds of the Zambian people. And the Zambian government subsequently failed to garner enough votes to pass the bill. A victory for all. In short, and in summary, public interest litigation can be an effective tool for social change. It requires brave citizens and lawyers to bring these cases forward, and even braver judges to ensure that justice is delivered. But as I mentioned earlier, sometimes you may lose the battle, but win the war through using public interest litigation as an advocacy campaign tool. Public interest litigation is necessary in every society to ensure that the governments adhere to their social contracts with the people they serve and to guard against impunity. To do this, we need to protect the civic space, the independence of lawyers, and of course, the independence of the judiciary. So I'll stop there. Thank you very much for your attention.
Thank you so much, Linda. You make a very important delivery. It is not always about winning. And I love how you won over the hearts and minds of the Zambian people. And I think also one of the things that happened with the Kabaziguruka case in Uganda is that the delays caused an uproar, and the delays in hearing this appeal caused so much uproar, and to the extent that even when the decision was made, the powers that be didn't feel like they had a choice but to implement, although that is still a whole way from implementing. I'd like now to invite my professor, Dr. Tinomjisha, to come and speak to us on public interest litigation. He can also speak to certain areas in which he believes it has contributed greatly, and also speak to the challenges sometimes faced in the implementation of public interest litigation decisions, or even the litigation process itself. Dr. Ben, you're very welcome.
Good morning, everybody.
Good morning. We can hear you loud and clear.
Okay, I also join others in thanking the Deputy Justice, His Lordship, the Deputy Justice, and the Attorney General, then the distinguished panelists and participants. Thank you for inviting me for this discussion. Although when I see people have been sending me a poster with a strange name under my image, but I think it has been corrected. Sambeni Kiromba Twinumugisha. I have been a teacher of law since 1986 up to today. I'll be leaving Makerere end of May to do some further teaching. And I'm grateful that we are here talking about public interest litigation, which now we call, in most instances, we now moved it into strategic litigation. I think public interest litigation, my talk largely will be about Uganda, but focusing on an area where I have greater interest, although I'm a multidisciplinary scholar because I teach commercial laws and also these other areas.
Dr. Ben, you've moved your camera. We can't hear you. Yes, thank you.
So can I be heard now, or I even remove the camera? Do I even need the camera anyway?
You can be heard, sir.
Yes, I can even remove the camera, not so?
You can. We'll put your picture if you prefer, although I'm sure your familiar face is something everybody wants to see.
Okay. So what I was saying is that public interest litigation, which at times now is known as strategic interest litigation, because it's very critical to know which cases you are bringing up. And I was saying, I'll talk largely about an area which I'm so familiar with, and that is the area of health rights and social justice. And I will handle this by way of testimony to see how some of these issues have come up. By the time our constitution was made in 1995, the Ugandan constitution, indeed there were struggles for the realization of some aspects of the right to health, especially in the area of sexual and reproductive health and rights.
Hello, doctor. We seem to have lost you. We seem to have lost the good doctor because of technology. When he gets back on, we shall revert back. We have one last poll as we wait for doctor. One of the polls, again, I told you would be shooting polls in front of you and getting some data. Please, participants, feel free to answer as soon as possible. We're looking at your motor skills and your ability to handle technology. Let's have our poll question as we wait for doctor to get back on.
No, I was there. I don't know what happened.
Oh, okay. Okay, thank you.
What happened.
You're welcome. Let's pause on the poll now.
Whether it was on your side, I don't know. Because I was on. So can I still be heard?
Yes, very clearly.
Yeah, so I was saying that by the time of the 1995 Constitution, the key question that was there is about socio-economic cultural rights, including the right to health. Because we know in the 1962 Constitution, even 1967 Constitution, although it had a rich part on Bill of Rights, of course, with a lot of clawback clauses, there was no direct provision on socio-economic and cultural rights, maybe the cross-cutting right of property. But in 1995, the Constitution touched some aspects of socio-economic and the cultural rights, but most of them, apart from the right to education in Article 30, the right to the right to a clean and healthy environment, Article 39, affirmative action, 32, women's rights, Article 33, so children's rights, Article 34. The other bulk of socio-economic cultural rights were placed in the national objectives and directive principles of state policy, which I may call the preamble, part of the preamble of the introductory parts of the Constitution. So during that time, in the around that period of the constitutional making exercise and the promulgation of the Constitution, that area of socio-economic rights was not clear. We hadn't gone deeper into that area of the right to health, and one could not even strongly talk about this public interest litigation. But remember, we had efforts by organizations like the Environmental Action Framework. We had people like the late Justice Kakuru, Counsel Philip Karugaba, and others who did a lot in terms of the area of the right to a clean and healthy environment to bring cases to court. And testing Article 50 of our Constitution, which provide the foundation for the constitutional foundation for public interest litigation, where it allows any person or group of persons, organization, to bring an action on behalf of others. But before that, before the 1995 Constitution, one needed a representative action, to bring a suit on behalf of others, which was very cumbersome, costly, and indeed, in some of the initial cases by the Environmental Action Network, what called the tobacco cases, the principal judge then, Justice Ntabugova, came up with opened up this area by interpreting Article 50 in such a way that allows, to the effect that allows public interest litigation. Of course, building on actions in other areas, like in Tanzania, the cases that were brought by Reverend Mutikila. And of course, later in South Africa, we're having these other cases, like one which has been talked about, Minister of Health and Treatment Action Campaign, Subramania versus Minister of Health, later government of the Republic of South Africa versus Grootboom on housing. Subramania was on kidney transplant, someone asking for kidney dialysis, not transplant, kidney dialysis. And the court said that that person could not get it, and they used the question of resources. So within the area of socioeconomic rights, there has been that challenge. There was that challenge of as to whether they are justiciable or they are simply progressive, aspirational, given that under the International Covenant on Economic, Social, Cultural Rights, they are subject to the availability of resources. But then in 2002, something that revolutionized this area and which we use, and even our courts have adopted it, General Comment number 14 on the right to health, which brought out a very clear interpretation of the obligations of the state to include what we call minimum core obligations in this area. Moving fast forward, so around 1999, 2000 there, 1998 there, or let me see, 1980, maybe late 90s, I should say. It's about maybe 15, 16 years ago. I thought that this is an area that needs to be developed. So Justice Sachi and I started, she was teaching at Makere at that time, started a course called Health and the Law. And that time, I also decided to do a doctorate. Although my master's on environmental law and policy, I decided to focus on health rights because of some reasons. I may not go deeper into them, but one of them was to interrogate that question on justiciability of the right to health. And I was focusing on maternal health rights. So my pioneer students formed an organization to the students. Moses Murumba, Professor Moses Murumba is now an associate professor at the University of Northern Texas, but also here as Director General of Afya na Haki. Then David Kabanda, who is now heading a food rights organization separate. And we started interrogating this question of justiciability of the right to health through public interest litigation. So moving fast forward, one of the major areas, cases we handled to test this area was what we call Petition 16 of 2011, Center for Health, Human Rights and Development, and 3 others. I was one of the petitioners, versus the Attorney General. And by the time we filed this petition, maternal mortality rate in Uganda was high, like in most parts of Africa, at 438 women dying per 100 live births. And remember, that's mortality, but the morbidities, the debilitating injuries these women would face in the course of giving us life, including the dreaded fistula, were not recorded. And one lady lost her life in Arua, and we took up that matter and challenged the government in the Constitutional Court for, among others, failure to provide essential maternal health commodities in public health facilities, leading to violations of a whole range of rights, including women's human rights, under Article 33, right to life, Article 22, freedom from torture, cruel, inhuman, degrading treatment, which is non-derogable, and other rights. So when we were in the Constitutional Court, the government, the Attorney General, raised the preliminary objection that the matters we were raising breached the doctrine of separation of powers because they delved into matters that can only be solely handled by Parliament in terms of legislation and policies and other administrative measures on the side of the executive. And the judges relied on the political question doctrine, which had been long described even in the US, to say that our petition did not have strong ground to continue, and it was dismissed. And this, of course, touched us strongly because a few years ago, a case that had attempted to challenge government in this area, the case of Joyce Nakachwa, where she was mistreated as she went to a hospital for delivery, and mistreated by local officials, including forcing her to open her private parts in public. I will not go deeper into detail, but the case abated, the petition abated because she died. So we're a bit discouraged, but one lesson I learned from public interest litigation or strategic interest litigation is that, as the previous speaker said, you don't go to court, say that in all cases you win, and you don't give in easily. So we hired some external lawyer working with our internal lawyers and went back. Went to the Supreme Court, filed an appeal, and the appeal castigated, I'm sorry to use that word, the Constitutional Court for abdicating its responsibility to at least give direction as the place of the right to health in our Constitution and in our jurisprudence, given that in our Constitution, Objective 20 and Objective 14, which provide for the state's obligation to provide medical services and other health services. So the Constitutional Court sent back the case, the Supreme Court sent back the case to the Constitutional Court. And I have to say that the Constitutional Court gave us a jewel of a judgment, agreeing or granting all our declarations or prayers, declarations and orders. And some of these orders involved structural interdicts, which again, as the Deputy Chief Justice was mentioning, these are new things, but which judges have acquired through training. And I would like at this juncture to thank one of our professors, one also of our former students, Professor Christopher Mbazira, who when he returned to South Africa, he taught through trainings, most of us in this area of socioeconomic rights. And through the trainings we had conducted for the judges, so the judges were able to appreciate all these issues and they come up with a judgment. And this judgment in petition 16, petition 16 of 2011 by the Constitutional Court made a number of jurisprudential achievements. One, it declared that the right to health was justiciable. Remember, we had an amendment in 2005 where Article 8A was incorporated in our Constitution, saying that the national objectives and ethical principles of state policy were now, in effect, binding on all organs of the state, including, of course, the judiciary. And indeed, the Constitutional Court and the Supreme Court, and even the High Court, they have now been applying national objectives. So, apart from having the right to health justiciable, the second achievement is that the national objectives and ethical principles of state policy are now, without question, justiciable. Number three, unlike the South African and Kenyan constitutions, for example, that expressly provide for the application of international law in the constitutions, in Uganda, apart from one of the objectives which says that Uganda's foreign policy shall be based on its international obligations, and Article 45, which says rights and freedoms which are not in Chapter 4 can be applied. We now had the Constitutional Court applying international law directly, including General Comment number 14 of the Committee on Economic, Social, and Cultural Rights, including the obligation to respect, protect, and fulfill and these minimum core obligations, directly applied by the court. Then another important point is that we saw the Constitutional Court citing and applying with approval, a judgment of a lower court, the High Court, judgment by Lady Justice Mugambe in one of the cases which one of the organizations I chair, SEHAD, brought in, where a baby was lost in Mulago. And they quoted most of the holding of Justice Lydia Mugambe. So that case propelled a lot of efforts in the area of public interest litigation, public investigation in the area of health rights. But of course, one challenge that comes out is this case was decided like many other cases. The question we need always to find out is, if you bring out a case and get an order, we get these declarations, that's a major step, but the journey maybe has started. So around this case and even after, SEHAD, Center for Human Rights and Development, which was one of the petitioners, decided to engage in advocacy because, as the previous speaker said, public interest litigation is an advocacy tool. You need also to have political mobilization around it. To mobilize communities, to mobilize society. So what did we do? We engaged legal experts, including practicing lawyers, to discuss the silent issues surrounding this. But we had even community dialogues in order to understand and appreciate the issues surrounding the case. We had to take the case, the discussion of the case, in accessible and simple language to the grassroots for them to understand what we are talking about. Because with public interest litigation, or even strategic interest litigation, if you are careful, it may empower the elite, and then the voices and the marginalized may not even derive an agency from it. They may not be empowered. So you find the organization, the lawyers who have handled the case, they are shining, but the grassroots organizations, the individuals, the indigent, those ones who are marginalized, on whose behalf this case has been brought, are not benefiting. So our organization had to go deeper into the communities to explain to them what the case is about. And we also, with other civil society networks, we formed a diverse coalition, what we call Coalition Stop Maternal Mortality in Uganda, because the maternal mortality rate by the time we filed the case was 438, as I said. In 2016, it dropped 336, but this followed the advocacy we made, including when we went to Parliament. We walked to Parliament. I was part of the leaders of the demonstration, walking from the Independence Monument to Parliament. We demanded a meeting with the Speaker. The Speaker was gracious. She had just flown in the country. That time she was Honorable Kadaga. She met us, addressed us, and Parliament passed a resolution on maternal health. And all this coming out of Petition 16. So that work we did, we had to make sure that we move out of the courts and we go out to society to demand transparency and accountability from the relevant organs. So we even involved the media, because with public interest litigation, one, even when you win or lose, you must engage the court of public opinion, and that's the media. So we have to make sure that civil society organizations, individuals, public interest, public spirited individuals who are interested in this area of health rights and social justice and maternal health rights come to court with placards, with T-shirts. Some placards reading 16 women died due to preventable maternal deaths. A matatu, a taxi full of 16 passengers died, crashes per day. So we had to appeal to that, because judges are also human beings. They sit on the bench with their minds. So this lobbying is important in terms of involving the media so that these issues are debated in the court of public opinion. And as we continued with this case, we were again carrying out trainings for judges, create trainings for the media, because to me, public interest litigation offers an opportunity for learning for lawyers themselves and for judges, because a number of judges, especially those who are like my age or above 50, may even not have studied human rights. They have not interfaced with health law and policy, medical law, etc. So it's a learning missions and what they present to judges, so that the judges are able to learn from this.
Doctor, we are running out of time.
So I'm concluding. So as I conclude, I'm saying that public interest litigation is very critical in these areas, especially areas that are not clearly defined. As I said, in Uganda, started with the right to clean and healthy environment. We can say environmental rights are now fairly defined here. And we have to train the judges. We have to continue training ourselves as lawyers, continue the legal training in these areas, and we shall reach there. Thank you very much.
Thank you so much, Doctor. You've done this justice as a don, not only in academia, but also somebody who has been on the streets with boots on the ground at the front line, struggling for policy reform through public interest litigation in various sectors, not only health, but others as well. Thank you so much. Members, if you have questions, please add them to the Q&A. And we are now, and that includes questions for Dr. Folida Katsonde. Now we're going to FIDA Uganda. Susan Baluka, please come in and give us this story. I'm going to request that you restrict yourself to 5 minutes because our time is fast spent and we need to have some questions from the audience. I'll have to sacrifice my own questions to the panelists. Yes, Susan?
Thank you
pressure.
very much, Fiona, for having me. Hello, Fiona, can you hear me? Hello?
Yes, we can hear you.
Oh, great. Thank you very much, Fiona, for having me. And it's a pleasure to be on a panel with distinguished ladies and gentlemen, some of whom have actually taught me, like Professor Tunongisha. I know that our time is fast spent. So in line with the framework of discussion, which is really what are the gains of public interest litigation, what are the gains, what are the losses or gaps? I will focus on that with regard to rights of women, advancement of women's rights, and advancement of gender justice. And in terms of gains, I will focus, number one, on progressive jurisprudence, gender progressive jurisprudence, gains in terms of the legal framework for public interest litigation, and gains in terms of capacity building, which is something that has been talked about both by Professor Tunongisha and the Honorable Deputy Chief Justice. So in terms of gender progressive jurisprudence, I know that the prior speakers, including the Attorney General and the Deputy Chief Justice, have spoken to a number of decisions that came from the Constitutional Court that speak to rights of women, especially with regard to family justice, as we saw in the case of FIDA Uganda and others versus Attorney General, which nullified provisions of the Divorce Act that made it easier for men to access divorce and more difficult for women to access divorce. Yet this is something that is actually very much correlated to the broader ambit of issues pertaining to women's peace and security, especially as we see it presented in the Maputo Protocol, specifically with regard to how it relates to intimate partner violence as a form of gender-based violence. Another key important decision that led to gender progressive jurisprudence is the case of Nihume versus Attorney General that declared the return of bride price unconstitutional, as well as the nullification of gender discriminatory laws in succession, gender discriminatory provisions in the Succession Act under the Law and Advocacy for Women versus Attorney General case. I would also like to point to the fact that public interest litigation has been instrumental in advancing sexual reproductive health rights for women, as has been discussed in detail by Professor Tunongisha, but also to add that in addition to maternal health, there are a number of other aspects that relate to what is in gender justice discourse is referred to as violence against women within the health system. And so you have seen other cases, still again from SEHAD as a leading institution in health rights, taking one other cases such as the declaration of holding patients hostage because they have not been able to pay their medical bills, both in private and government facilities, and basically having decisions that speak to the fact that that is in fact a violation of fundamental human rights and a violation of the right to dignity, of which we have seen a number of women actually being subjected to this form of human rights violations, especially after they have given birth. So there is a lot of jurisprudence that has also been developed on the aspect of violence against women within the health system. Another key area in which jurisprudence or gender progressive jurisprudence has been developed is the area of labor rights. We most recently saw a decision where the Women Pro Bono Initiative, a women's rights NGO that represented a woman that sued a private recruitment company for violating the rights of her daughter while she was in Saudi Arabia. And basically, this is a decision that we see, first of all, creates jurisprudence in terms of horizontal enforcement of human rights, that is enforcement of human rights as between private citizens, as opposed to the usual the more common dynamic where we see vertical enforcement of human rights, basically private individuals suing the state for either violating or failing to fulfill their human rights obligations towards them. So this case creates a kind of jurisprudence, but it also creates jurisprudence in terms of enforcing the duty of recruitment companies towards migrant workers as under the employment recruitment of Uganda migrant workers regulations, which is something that has not been upheld for a very long time, and yet we see that women are disproportionately affected by various forms of human rights violations as migrant workers. I would also like to highlight that in terms of the legal framework for public interest litigation, there have been a number of gains, especially with the Human Rights Enforcement Act, which was passed in 2019, which basically streamlines procedure law for public interest litigation, especially within the High Court, because as has been discussed, public interest litigation happens both at the level of the High Court and also the Constitutional Court. And then also in terms of capacity building, we have seen some gains in terms of more emerging capacity building initiatives coming up. I'm sure a number of us here who practice as public interest lawyers have attended a number of institutes pertaining to strategic litigation or public interest litigation. Particularly at FIDA, we have worked with the Center for Strategic Litigation to build the capacity of some of our staff members to engage to litigate as public interest lawyers. And we also have institutions such as the Initiative for Strategic Litigation in Africa that have institutes for feminist strategic litigation. So basically building the capacity of female lawyers to litigate from a gender perspective on public interest matters. And that has been very instrumental in terms of gendering the way in which lawyers develop their cases and make their arguments in court. In terms of losses or gaps or missed opportunities, with regard to losses or missed opportunities in development of jurisprudence, I will say there were missed opportunities in some cases. For example, the case on law in law and advocacy for women, where various gender discriminatory provisions of the Succession Act were found null and void. The court did state that their duty was to simply make declarations. And so when they made declarations that basically was saying provisions X, Y, and Z are unconstitutional and left it at that, that actually did create discordance within the legal framework, where then different judicial officers will interpret the implications of that declaration, in accordance to their own understanding. So that was a missed opportunity in terms of courts making giving transformative remedies that go as far as giving guidance in terms of giving more specific remedies in terms of either things like reading in or omission in the text of the statute, or even as far as giving directions that pertain to amendment of the laws within a specific period of time, which is well in line with the remedy of structure interdicts that Dr. Tunumgisha has spoken about. So that created a bit of disorganization within the litigation of succession matters until the Succession Act was actually amended, and the law was actually amended to taking into account the decision of the Constitutional Court with regard to that act. But you can imagine the time that it took between the issuance of that judgment and Parliament's actual revision of the law, and how that created uncertainty within the justice system. Again, with regard to jurisprudence. Yes, there is jurisprudence, but then I like the person who asks, okay, when you have the jurisprudence, then what? So a lot of the good decisions that we got, especially when it comes to decisions pertaining to harmful cultural practices like the issue of bride price, even female genital mutilation, these are decisions that when you engage with the communities in the different regions of the country, these are practices that are actually still ongoing many years later after we have the judgment in Mifumi. A lot of women still undergo customary divorces and they are required to pay bride price. So that indicates that there is a gap with regard to implementing some of these judgments that we get. And then also with regard to missed opportunities, and this I believe speaks to what the Deputy Chief Justice spoke about. How do you, as a public interest litigator, present your case before the court? What are the prayers that you're making? And one of the gaps or losses or missed opportunities that we have seen in some of the cases we have handled is that we have won cases, yes, that may speak to rights of women, but most of those cases are on the premise of the fact that particular acts or missions or laws violated the right to non-discrimination from the perspective of direct discrimination. And so we have not had the opportunity to actually have the courts pronounce themselves on or create jurisprudence around indirect discrimination, which is a form of discrimination that also affects women in very many aspects, but is easily missed because when people look at the law, when people look at the practice, they'll say, but how does that, how is that discrimination against women? And that is because we live in a society that is highly patriarchal. And so seeing beyond certain nuanced forms of gender-based discrimination is a bit difficult. So I'll just give the example again of one of the most recent decisions.
Hi, Susan. We'll give you like 2 more minutes so you can wind up.
Yes, please.
You're really riveting, but the time.
So one of the most recent decisions, I'm sorry, let me just make this point about indirect discrimination and the jurisprudence that we have. So one of the most recent decisions that we got, it's not even a decision about women's rights per se, but the decision from the Constitutional Court that declared the provision of being rogue and vagabond unconstitutional. When I looked at that judgment, when I read the judgment, it was basically the decision basically declared the provision unconstitutional because it did not meet the constitutional muster of under Article 28(12) on being clearly defined. But one of the other arguments that had been made by the petitioner was that it was actually discriminatory on the basis of class, because it is mostly, it is mostly less economically privileged persons, people who, are in the informal economy, who are always vending on the streets, young men who probably live in more than less affluent areas within different parts of the city, that often wound up getting arrested under these provisions. So, but that argument failed. And one of the reasons that was fronted by the court was the aspect about evidence. And so again, there is always need to have discourse. I think there's need to have clarity. I don't know if it can be established through training or continuous or litigation that specifically addresses that issue in public interest matters. So the court said that one of the only evidence that was presented by the petitioner on that issue was research that they had done that actually, showed the different categories of people that were always arrested under that provision. And the court went on to say, well, if only one of these people had come up to give an affidavit. But because I was part of the process of developing that case in my previous place of employment, I know that it was so difficult. In fact, it was impossible to get a willing person that had been affected by this law to swear an affidavit to even be a petitioner because of the perception of suing the government. So I feel like there is a gap there in terms of evidence in public interest matters and the realities of it all when it comes to willingness of people that are actually affected to come forward. Now, why I feel like that is important for women's rights, because the argument on discrimination on the basis of socioeconomic class was actually an argument that would set good precedent even for women's rights litigation or gender justice litigation in as far as indirect discrimination is concerned, because the provisions don't say we are only going to arrest economically disadvantaged people. No, but somehow the implementation of it and of course, given the colonial history of it all, affects less economically disadvantaged people. Thank you.
Thank you so much, Susan. That was a rich presentation. I hope we'll get a copy of it for our audiences, of our audience. And it's very interesting how you speak to the fact that sometimes when we do this public interest litigation, we don't realize the far-reaching consequences of it, but also we don't realize that we still have to advocate for the rulings, if positive, to be implemented. There's also that. But then we've had, I think an organization like FIDA sometimes has been burdened that not only do you do appeal that actually addresses gaps in legislation and proposes reforms, then you also have to go back to the drawing board to help the draftsmen, and then go again to lobby for the legislation to even pass. And we've had some legislation, I think, has been in Parliament for over 15, 20 years. And these are some of the challenges. But I really appreciated your very, very succinct examples of what FIDA Uganda and all over Africa has done. And we appreciate the examples that you've given us. And I hope that we can have further discussions, especially around growing public interest litigation capacity, especially that is specifically aligned to particular practice areas. I like that FIDA has been training its teams along the lines of its practice area. And sometimes we think that anybody can do public interest litigation, but as you emphasized, there are very specific nuances to each area of practice. And I think Professor Twinomchisha also really spoke to the aspect of specialization, to the aspect of getting in, because sometimes we become our clients in many ways, and you cannot just do general appeal. So the issue of I think you really speak very well to the issues, to the aspect of specialization. Thank you so much, Susan. And now we have from CEPIL. I really wanted to hear from CEPIL after Susan, because CEPIL is one of those organizations that has been intentionally addressing PIL issues for a while now. Lilian Agwang, this is to welcome you, Acting Executive Director, CEPIL. Please speak. I'll give you, we don't have a lot of time for Q&A, but I'm hoping that you will be able to finish within 7 minutes.
Okay. Thank you very much, Senior Counsel. I would like to also thank the esteemed panelists that have made their insightful presentations. Because of time, I'm not able to get into everything that I had planned to speak about. However, I would like to go straight into the key gains of PIL. I'd like to say that CEPIL focuses on ensuring freedom of expression, protecting vulnerable groups, promotion of environmental justice. So I will focus on those 3 areas because of time. We see that one of the key gains of PIL is that it has promoted freedom of expression. CEPIL supports and protects media rights. So we see that in Tanzania, in the case of Mtkila versus the Attorney General 2013, the High Court ruled that the government's ban on a newspaper was unconstitutional, protecting the right to freedom of expression. So that's one of the gains that we have reached. Then under protection of vulnerable groups, CEPIL has been was part of petitioners in the case of Honorable Retired Justice Okello Omoro and 4 others versus the AG and 8 others, whereby judgment was made in favor of the petitioners, CEPIL being the 5th petitioner, whereby they say that it was not okay for the district land boards to have authority to manage customarily held land, and that was a good thing for the people that were in the Chole land, because they were being marginalized because of that space. Now, when we go to South Africa, this was mentioned by one of the panelists, that a court case was ruled that against the government's failure to provide adequate housing for people living with HIV/AIDS, and it was a violation of their rights. So we see all these cases, won their petitions in court, and these are the gains of PIL. We look at promotion of environmental justice. This is an area whereby I am trying to ensure that we get into seeing how we protect the environment. When we get into the communities that are deep outside Kampala, you find that many of the people are marginalized out there. I've heard of a company, I read it in the newspaper, whereby there's a company that was doing fishing around a lake, and they condoned it off, and meaning that all these youths that used to go and earn a living from fishing, from selling that fish, they used to do some farming around there, they could no longer do it. So as CEPIL, we are starting to look at promotion of environmental justice. We can see that in Ghana, there was a case in 2012 where the High Court of Ghana ruled that the government's decision to allow a mining company to operate in a protected area was unconstitutional and a violation of human rights. One of the other gains of PIL is that there's been protection of electoral reforms and governance. I'll say in Uganda here in 2016, the Supreme Court of Uganda ruled that the Electoral Commission's decision to disqualify a presidential candidate was unlawful, demonstrating court's ability to check the commission's power. Also in Kenya, in 2017, the Supreme Court of Kenya annulled the presidential election results due to irregularities. This is all because of public interest litigation. We also see that in Tanzania, women were empowered under the Tanzania Women Lawyers Association in 2010. An awareness was raised to prevent violence against women and empowered women's rights to challenge discriminatory laws and advocate for policy reforms. Also mentioned by the Attorney General, we see a case in Uganda, Sehad versus the AG 2013, whereby the High Court of Uganda ruled that the government's failure to provide essential healthcare services was a violation of rights to health. So all these are gains of PIL. But we cannot talk about gains of PIL and not talk about the challenges. I've categorized these challenges into 3: under corruption and impunity, resource constraints, and repressive legislation. Under corruption and impunity, we find that there is lack of judicial independence. There is inadequate training or insufficient resources that hinder effectiveness of PIL. We also see that sometimes there is interference by the government over the judiciary, and this can undermine the rule of law and PIL. When we go to resource constraints, right currently we are all undergoing the ban, most of us are undergoing the ban that President Trump constituted recently, and this has limited financial resources because this was an immediate ban. So this has affected PIL and is going to continue affecting PIL. We have repressive legislations, we have restrictive laws and regulations that stifle civic space and limit the ability of civil societies to engage in PIL. PIL has also suffered a number of losses. I'd like to talk about that in a bit. One of the losses is delays in justice delivery. Cases take long in court. For some, it's not easy to get a hearing date. So just like it was mentioned by one of the panelists, it takes over 12 years or very long. So this is really affecting PIL, and I would like to appeal to the judiciary to ensure prioritization of the PIL cases. We also have sometimes unfavorable court decisions. Sometimes we have backlash against activists and lawyers who are just trying to ensure and protect the rights of the marginalized people. Because most of us have talked about the gains, the challenges, and the losses, I would also like to add on to this and speak about the recommendations. What's the way forward after all is said and done? What are we going to do? What are we going to advocate for? One of the ways forwards that I recommend for your consideration is strengthening judicial independence. We should continue advocating for legal reforms to reduce political influence, but also to support the judiciary to do its work well. And that is by ensuring that as civil society or as lawyers or as in whatever capacity we are, we contribute to ensuring that there's enough capacity building and training for the judiciary and also for PIL lawyers. We should also ensure that we have enhanced collaboration, just like it was mentioned by Senior Counsel Fiona, partnerships. Partnerships is very important in this, our work that we do. It's important for us to partner. Now that we do not have enough resources, we have issues in regard to donors. It's important that at this point in time, civil society, organizations, bar associations, we come together, pool resources together, and ensure that we strengthen public interest litigation in Africa. Capacity building, I have already talked about capacity building. We should ensure that there is continuous capacity building. Public engagement, increasing awareness and citizen participation in the legal process. In regard to increasing awareness, I would like to go to the recent judgment in regard to the Kabazi Guruka case. In this judgment, it was said that the ruling sent a clear message that military courts should not have jurisdiction over civilians, and establishes a binding precedent that civilians must be tried in civilian courts where their rights to fair and impartial trial can fully be protected. But if I am to pose a question, how many civilians are aware of this judgment? I'm sure it's around 40%, the land profession, but the civilian that is out there in the community, deep in the village, is not aware of this. So it's important that as we want to strengthen public interest litigation, let us look at ensuring that we are working to ensure that the public is aware of what we are doing, the public is aware of the decisions, the public is involved, and we can only do this through increasing awareness and citizen participation in the legal process. So as I conclude, I would like to give a call to action to all legal professionals, policymakers, civil society representatives. Let's not give up. Let's not give up. Public interest is a good thing. And instead, let's encourage one another to advocate for legal reforms that strengthen public interest mechanisms. For the future, I see that there is a lot of work for us to do in areas as digital rights, climate change litigation, and corporate accountability. Thank you for listening.
Thank you so much, Lillian. You've done a fantastic job. I'm very grateful that you actually talked about the way forward. I want to address our participants and let you know that there is another poll. I promise this is the very last one on the future of public interest litigation. thinking about that clarion call that Lillian has given us, what do you think is the most effective way to strengthen PEEL in Africa? Please answer that, Paul. And we want to let you know that we have been live on LinkedIn. We have been live on YouTube at the Fidelis Leadership Institute pages. And the content will stay on there. I know a lot of members of the judiciary and advocates who kept texting and saying they were in court or they were busy. So please share the links widely. I'd like to also request, because we want to keep doing better. Please give us your feedback in the chat. In the chat section, we have put a link for our feedback form. It's very short. It will take you 2 minutes. Just give us some honest feedback so we can learn and get better. As you can see, we say that we're faithful, available, and teachable. So in the spirit of being teachable, please. So our participants, I want to ask you to join me to thank our eminent panelists who've done a fantastic job of telling us everything about public interest litigation, the impact it has had, how it can be used for the socio-economic transformation of Africa. I would like now to ask each of them to give us one last clarion call. I'm hoping it will be a sentence because we want to end at midday and we have 5 minutes. I'll start with is Donald Bear still around? I'd hope to engage him more, but I don't see him. Okay, I'll start with Linda. Linda, would you like to say something? Your last clarion call. Oh, I don't see Linda.
I'm here.
Dr. Twinomcha, would you like to? Oh, Linda, yes, please give us your last clarion call.
I think I mentioned in my presentation, but essentially, public interest litigation requires citizens to bring the cases to court. It requires brave lawyers to represent them, and it requires an independent judiciary to uphold justice. So I think we, particularly in the legal profession, have a lot to do to make sure that we raise lawyers that have the gumption to take such cases up and to see them to their logical conclusion. So I think that's really the clarion call for, this work is difficult and sometimes even dangerous. So those of you who've taken an oath when you become lawyers, take your oath very seriously to defend and protect the Constitution. So that, I think, would be my concluding remark. Thank you.
Thank you so much, Lillian. Professor, would you like to take it?
Yeah, thank you very much. Just in a minute. I think the success of public interest litigation requires one, knowledgeable lawyers who have to be prepared. And I say the word prepared 3 times. Prepared, prepare, prepare, and prepare. Because we have read some cases, even including some from our organizations, where judges complain that, for example, the pleadings were clumsily drafted. So let's be careful as we bring matters to court. And that even includes the submissions. Let them be well researched, because as I said before, we are also educating the judges. Number 2, the judges should be innovative and creative. Like judges in Uganda, I don't see why a judge should even fumble or panic, because our constitution guarantees them independence from control of any authority. If there is a job that is so secure, with a strong security obtainer, it is that of a judge. And they are even now well rewarded. And let them know that they are administering justice in accordance with the aspirations, the values of the people. They must be creative. You may call it judicial activism if you want. Number 3, and lastly, let public interest litigation, as the name suggests, represent the public. Let's not promote our own interests as organizations and as lawyers, forgetting the public whom we represent. Thank you very much.
Wow, thank you very much. That is very powerfully said. Susan, one last word.
Thank you, Fiona. As we close, the clarion call to each and every one of us as public interest lawyers or lawyers that are interested in venturing into the field of public interest litigation. Number one, we should be deliberate about cross-jurisdictional learning on new ways of making arguments on different issues, because that is how we create progressive jurisprudence, no matter the area: human rights, environmental rights, women's rights. We need to, as much as possible, seek new information, seek new learning, and be deliberate about it.
Thank you, Susan. Lillian, you had already given us your clarion call. Ladies and gentlemen, we have come to the end. I hope that you've been kind enough to go to the chat section and give us feedback by filling in that feedback form, which will take you 2 minutes. It's on a link. I want to thank everybody who's participated in our poll. Please, you can keep answering. We're about to share the results. I think I should share it now. And it really says that the biggest thing we need to do is strengthen judicial independence, and we also need to equally increase funding and greater collaboration between civil society and legal professionals in the struggle to ensure that PIL is sustainable, it is effective, and it is strengthened in Africa. I want to thank our Honorable Deputy Chief Justice, our Honorable Attorney General, our Honorable panelists, especially all of you, led by our keynote speaker, Don Dare, and Ms. Susan Baluka, Dr. Ben Twinomcha, Ms. Lilian Agwang, Ms. Linda Kasonde, and everybody that has taken the time to be present, to participate, to ask questions. The future of public interest litigation is very important. And I want to state that as the Fidelis Leadership Institute, we're going to keep on partnering with other civil society organizations and other with more lawyers to see that we train and equip ourselves, but we also approach PIL with strategy. We need to look at the socio-economic issues in our jurisdictions as Africans and see how we can use our tools, which is really the law, and get into the war room for lawyers, which is the courtroom, and actually drive progress, force legislative reform, and even bring rights and justice to those that have no voice. One of the things that has come out is that these human rights abuses and injustices and poor governance sometimes are not a deliberate thing from our leaders, but we need to keep drawing their attention to what matters. I think it was Dr. Twinomcha who talked about the importance of channeling budgets to the right things, channeling legislation to the right matters. And because of that, I think that the clarion call that everybody has given here is, even when we are doing PIL, we need to be exceptional. We need to prepare. We need to not sabotage our cases. I've seen some lawyers sabotage maybe their environmental cases or something by putting all their evidence on social media and arming the other side, or even sort of politicizing their own litigations, which then sometimes causes the cause to be lost. There's been a caution from all our panelists that the motive matters. It's good for us to understand the why of what we're doing. And as the Fidelis Leadership Institute, we want to thank Pan-African Lawyers Union for joining us. We want to thank FIDA, want to thank CEPIL, want to thank Makerere University through Dr. Twinomsha. We want to thank everyone that has partnered and been with us. We want to state that we shall continue having programs throughout the year. I want to call your attention one last time to the Fidelis leadership trainings. We have the regional conference on competition regulation and consumer protection, which is for 11th to 13th June this year. We want to grow the capacity of Ugandan and actually of East African lawyers and other professionals in managing issues of competition, regulation, and consumer protection, especially in the wake of the ACFTA. We are also going to have an arbitration and dispute resolution training around in trade and regionalization slated for October 2025. We're also going to have a masterclass on legislative drafting and intellectual property slated for November 2025. So please mark these on your calendar. If you want more information from the Fidelis Leadership Institute, please feel free to email us at info@fidelis-institute.org. We also are building the competition and consumer protection network of East Africa. And if you'd like to join us as a member, you can also send information to ed@fidelisinstitute.com. So lastly, I want to thank everybody. I want to encourage you as we go away. Let's prepare. Let's train ourselves in the particular areas where we want this to matter. But let's collaborate. We will go further if we are together. Thank you very much and have a fantastic Friday. My name is Fiona Wall, Executive Director, Fidelis Leadership Institute. I want to thank Abubakar Chaibu, Flora Chebet, Grace Naiga, Hawaship Pachave Prosi, Ambrose Kitenge, Angela Mutale. I might not have some of your titles, but I want to thank you all and recognize you. We have Grace Mima, Ronald Sim, Yona Banda, Alfred Madaba, Nabili Shipena, Ochaya Maxwell, Witness, Cynthia Mwansa. Thank you so much for being with us. Grace Ajaneza, Samson Azimwe, Ngavazize, we have Salim Ibrahim Mugisha, and Twataizia Kasanda, Abdul Gwanadi, Marion Benbela, Mikirize Naomi, Masereka Martin, Aulo Sarah, Zimei Sultan, Gaspard, Sarah Abdallah. Yeah, wow, it's good to hear from you, Katrina Joshua. It's really amazing to see all these people from all over Africa, and I'm hoping that we'll get to hear more from you in our next